Good afternoon, everyone, and thanks for coming to today's seminar where I'll be talking about the current world of non-character cancellations, the BVR, and potential removal risks. I am a migration lawyer here at Kris Ahn Lawyers. All I do at the moment is migration. I'm dedicated to providing support to ordinary people who face visa and citizenship issues in a very complex legal system. And here are the aims of today's session. At the end of today's presentation, you'll understand why and how visas can be cancelled, and following that, the why and how of those who have had a visa cancelled can be removed from Australia. I'll then talk about the BVR, which is a bridging visa that you can get while you're being removed, and some recent cases that have these themes. So the aim is not just to understand the law, but to understand the sequence, because that's what we'll be dealing with in practice. But first, let's go back to the basics. At its core, a visa is best understood as a statutory permission that is granted by the government. It's not an automatic entitlement, it's not a human right, but at the same time, it's not something that the minister can just hand out or refuse or cancel whenever they feel like it. Everything has to be exercised according to the law. And that distinction really matters, especially when you start to challenge decisions to cancel a visa or to refuse a visa. So you make your application, and the minister will go through and have a look at whether the criteria is met. And then after that, if all of the Schedule 2 and 8, and in some cases SRC and PIC criteria, if all of that is satisfied, then it will be granted and can be subject to certain conditions. And that is enabled by Section 41 of the Act. So once you understand that a visa is a permission that is granted under statute, the next logical step is to understand that what is given can also be taken away. So the visa can only continue if the basis of the grant remains acceptable. And broadly, there are several key cancellation pathways. The first one being Section 109 in conjunction with Regulation 2.41. And this is cancellation of a visa if information is incorrect or bogus. Section 116. These are the general cancellation powers, including condition breaches, risks to health, safety, or good order, or changed circumstances. There's Section 128 as well. So this is offshore cancellation that is based on the Section 116 grounds. So whatever condition was breached or whatever circumstance that happened that is covered by Section 116, if you're not in Australia yet, they could still cancel the visa. And separately, Section 501, which are the character-based cancellations. So now we have an important practical point. Except for automatic cancellations don't just happen because there is a ground for cancellation. So for example, I know a lot of student visa holders who are not supposed to be working more than 48 hours a fortnight, but nonetheless, they've worked and they've received cash in hand. And because they haven't reported it to the ATO or anything, no one knows. So there's a difference between pure knowledge, right, or pure existence of a fact, and the department's knowledge of the fact, and also the trigger. So the trigger to making a move for cancellation. So even if the department knows that there is a ground for cancellation, the department might still not cancel. And that's why you must always look at the wording of the statute. If it says must cancel, then the power is mandatory, right? If it says may cancel, the power is discretionary. And a discretionary power opens the door to submissions, evidence, and arguments about reasonableness and proportionality. But a mandatory power leaves far less room to move, even for the delegate. So the delegate would be in a situation where they're like, look, man, I can't, it's not me, it's the law. And for automatic cancellations, these cancellations occur by operation of law. So for example, Section 140 provides a couple of scenarios where the secondary, so the member of the family unit's visa gets cancelled automatically. because the primary holder's visa is cancelled. So when you see a cancellation, you've got to ask yourself, is this a discretionary decision, a mandatory outcome, or an automatic legal consequence? Because that will tell you what notice you should have received and what you can do thereafter. And the thing about this mandatory and automatic cancellation is that there's no notice. Whereas with the discretionary one, natural justice does apply. An NOICC, or a notice of intention to consider cancellation, will be sent, and the visa holder can respond within a specified period. So if a visa is cancelled, right? Let's say you did everything, it was even for discretionary cancellation, tried your best, made the submissions, sent out all of the evidence, and it still got cancelled. Then what happens? If a visa is cancelled, the legal consequence is immediate and absolute. It ceases to be in effect. And that is reflected in Section 82 of the Act, which tells us when visas cease, when visas end, when the visa is finished and you are no longer holding a visa. There's no grace period or transition period, right? And the interesting thing is, I don't know why when I started out in migration law, I used to think that, maybe they get a bridging visa. But I got completely tripped up. There is a tendency to think that a cancellation is similar to a refusal, but they are actually fundamentally different. If a visa application is refused, then the person usually continues to hold a bridging visa, right? Because their bridging visa was granted in the interim while their application for the substantive visa was being considered. And that bridging visa is valid for 35 days from the date of refusal, and usually, 28 days to seek review. And this is for, an onshore application, right? They will remain lawful for 35 days. By contrast, if a visa is cancelled, then the visa ceases immediately. There's no bridging visa because you just have the substantive visa, and the person just gets unlawful immediately, subject to Section 13 and 14. And even if you say, I was expecting the cancellation, so I had a backup plan. So I applied for another visa, and I've got a bridging visa in association with the new visa application. So go ahead, cancel my visa. I'm not going to be unlawful. Because of Section 82(7)(a), you'd still be unlawful because that bridging visa gets cancelled as well. Section 48 bar gets triggered as well. PIC 4013 gets triggered as well, right? So the 3-year ban could be triggered. Yep. And a string, if you've got MOFU, then Section 140 automatic cancellations get triggered as well. So if it's reviewable, then you could go to the ART, but sometimes cancellations are not always reviewable. So the key takeaway is that a refusal means that you never obtained the visa, whereas a cancellation means that you had it and then you lost it. And legally, that difference drives everything that follows. So we focused on the how and the why of visas getting cancelled. What matters in practice, however, is what happens after cancellation. Because cancellation is not the end of the story. It's the beginning of a whole new matter. It's the beginning of a whole new story. And the sequence is cancellation, unlawful status, detention, and removal. And if you understand that pipeline, you understand most of this area. So does anybody know where this place is? It's a screenshot from Google Earth. It's the dreaded Villawood Detention Centre. Question is, if my visa gets cancelled, do I get on a bus and just go there? Do I just rock up there and be like, hey, I'm unlawful, so do you have a room for me? Or do they round up people and then just chuck them in there? But let's have a look then at the immediate legal circumstances or consequences in practice. So becoming unlawful triggers a series of automatic legal consequences. So first of all, Section 198. 198 is critical. It provides that if an officer, reasonably suspects that a person is unlawful, the officer must detain the person. Now, once the officer detains the person, Section 194 says that the officer must let them know about Section 195 and 196. And note the language, it says must, which means that it's mandatory for the officer, or else they will have breached the process. So the officer needs to tell them that, hey, under Section 195, you can apply for another visa after 2 days of being detained. And under Section 196, they will remain in detention until they are either, number one, granted a visa, number two, removed, or number three, deported. So this effectively means that they just kind of get detained indefinitely unless one of those three things happen. So, okay, do I just get on a plane and leave? Not exactly. If a person has a valid unresolved visa application, particularly a protection visa, then under the provision of Section 1985A, that person must not be removed, right? So that's a protection, and it helps people sort of, have a fair chance at remaining in Australia. So the removal is not as easy as it sounds. It's mandatory in principle, right? So in principle, Section 189 says, oh, you've got to detain them, they've got to be removed, but it can be temporarily stayed by law. And now, a lot of people like to use the word deport instead of remove. The media loves to do this, especially, but there are a couple of important differences. Firstly, removal is an administrative procedure, whereas deportation is punitive. So what I mean by that is that removal under Section 198 is not like a sanction or a punishment or a penalty. It's simply the law's way of mechanically dealing with unlawful people. You don't have a visa, but you're in Australia? Well, you can't be here, so let's get you out. That's it. No wrongdoing needs to be found. But deportation under Sections 200 to 206 is different in character. It requires a ministerial order. It's directed at non-citizens in Australia, even those that have permanent visas, right? So you can still hold a visa and be deported, right? And it's mainly directed at these kinds of people who have committed serious, heinous crimes, or whose presence is contrary to the public interest. And this is, even if they hold a permanent visa. For example, a permanent resident, a 155 visa holder, can be subject to a deportation order under Section 201 while holding their visa if they've been convicted of a terrorism offence and sentenced to death or imprisonment for 12 months or more, which is the definition of a substantial criminal offence, right? And and if they've been in Australia for less than 10 years, then that's deportation. They can be deported. In practice, deporting is hardly done. Let's say that a client commits a really heinous crime. The minister could order the deportation, but usually what will happen is that the client will get their visa cancelled under Section 501. So rather than the minister being like, hey, I order this person, I'm putting down an order to deport this guy, it's more like they will get the visa cancelled on character grounds. And it's a lot more flexible that way. And so from the day that the visa gets cancelled, there'll be unlawful and, this whole process of Section 198 removal will follow. And for deportation, a good resource is to look at Ministerial Direction number 9. That shows the circumstances for deporting. But today's presentation isn't really about deportation. So we'll go to the next slide. Yeah, so after being detained and I'm not able to leave Australia and I don't have a visa, then do I just stay in detention forever? How do I get removed? Well, this is where the BVR comes in. So the BVR is specifically for people who are cooperating with removal efforts, but whose removal is not reasonably practicable at the time, meaning that the government hasn't been able to action it yet despite the person's cooperation. So this visa allows them to be released from detention. You can leave the airport, you can leave, I don't know about the airport, but you can leave Villawood while the department figures out how to get you out. And we'll cover this a little bit later. But before we go on, I want to talk about a different kind of cancellation and removal process, which are the airport cancellations. This is a high-risk scenario that happens to a lot of visitor visa and student visa holders. They come to the airport, the ABF says, hey, I noticed that you've been making too many trips to Australia. Or I have other reasons to suspect that you're coming in for the wrong reasons. Show me your phone. That's the first thing that they say. They take you to an interview room, or they take the client to the interview room, and then they say, show me your phone. This has happened to at least 3 of my leads and 2 of my current clients. The first client was also a visitor visa holder and was taking a connecting flight to get to Australia. And before getting on the plane, so before getting on the vessel, the flight attendant was like, someone wants to speak to you, and put him on the phone with the ABF. The ABF called ahead, so he couldn't come on shore. And after an interview, they came to the finding that he no longer met the GTE requirement. And he could no longer have the visitor visa. So that cancellation happened under Section 128 because for Section 116 reasons. So we were able to get the 128 cancellation revoked, which is good, and he ended up coming to Australia maybe a month later. The most recent client that I had, similarly, they also had a visitor visa, but the ABF put their phone through a software and found messages about rostering and about, like orders and stuff like that. So obviously, those kinds of messages suggested that there was a breach in condition 8101, no work. So you're not supposed to work on a visitor visa, and it looked like he did. So that led to a Section 116 cancellation. They could not be immigration cleared, so they just sat in the airport and had to be removed. The removal can either be a voluntary departure, like, yes, I'll book my own ticket out, or I'll use my return ticket that I had to go home now. But if they refuse to depart, or they couldn't afford a ticket, the government can arrange and fund removal. Now, what you could do is have the client, through their legal representative, make an urgent application to commence migration proceedings at the Federal Circuit and Family Court of Australia. This is called making an injunction, right? So everyone stop everything, stop my removal, because I have important proceedings to make at the FCA, FCOA. And I've got a tip. If this sounds like something that might happen to your current client, right? You already got the visa for them, it's granted, but you're not too sure, you think that they might get stopped at the border, make the client engage you again and carry a printed version of the 956 with them during the trip. So when the ABF, or if the ABF does say, hey, I'm going to cancel your visa, or I'm going to go through your phone, or I'm going to interview you, right? They will be able to say, hey, I do have a legal representative. I have a lawyer who helps me with my migration affairs. Because the ABF will be very, very unlikely to let them call a lawyer during the immigration clearance process. And they're very, very unlikely to say, hey, before we cancel your visa, or before we notice you with an intention to consider cancellation, do you want to speak to your lawyer first? They wouldn't do that. But in theory, they have to speak to the lawyer if they do see the 956. So that's a little tip. But not sure if you can see this very well, but for airport cancellations, I'll just show you what to do in practice. Because there's no merits review, the only pathway is judicial review in the federal court. Practically, it's in Division 2, so that's the part of the federal court that you're going to be looking at. You've got to use the court's portal, and the other thing is that you've got to do is, at the same time as making the online application, you also need to contact the registry by email as well and tell them that it's really, really urgent. This person is about to get removed from Australia right now. the jurisdiction for commencing the migration proceedings in the court is under Section 476 of the Migration Act. It doesn't fall under the definition of a reviewable migration decision for review at the tribunal. So the only pathway is going to be through the courts. This is a big shift for me personally, it was, because you're no longer arguing merits review. You're really arguing jurisdictional error at this point. So we're going to go through two cases, if we have time, three, about jurisdictional error in these in a scenario like this, but yeah, it's different to a merits review. So now we know how and why a person gets removed, and some of the removal risks as well, like how likely are you to be removed. We now come to the bit about the BVR, which is the subclass 070. The key point here is that this is a visa that can be granted if the government hasn't been able to arrange removal despite the person's cooperation. The visa allows them to be released from detention while they wait, especially if that detention is indefinite. And I think that the greatest cohort that this visa is relevant to would be that cohort of protection visa applicants. The matter is not finally determined. It might actually be at either the ART or even the, actually quite likely the federal court. And they aren't able to leave Australia either because that is still going, or everything has ended and they're still not able to go back. And you'll see why. So the key point here for the subclass 070, the bridging visa R, right? We're used to looking at Schedule 1 for whether an application is valid or not. But for the BVR, making a valid application is not something that you can do yourself. You can't just apply for it. Regulation 2.20A provides the process for making a valid application. And what happens is that the department, they will look at this person, they will assess the suitability, and they will refer it to the minister, and the minister will consider it and think, okay, should I invite this person to apply for the BVR? So the minister has to issue an invitation to apply, and that is governed under Regulation 2.20A. The person will get 7 days to accept the invitation, and the minister will grant the visa, and that person must still be in immigration detention at grant. They can't be offshore, like they can't have already been removed, because that defeats the whole purpose of the bridging visa. And they can't be out and about in Australian society at the time of grant either, because, well, they can only do that if they do get the BVR. If you miss the 7-day window, then the invitation lapses. There's no automatic right to reapply. There's no automatic right to an invitation. And there are a lot of conditions that apply to this bridging visa, the most extensive that I have seen. And most of them are monitoring and movement restrictions. To be considered for the BVR, the removal must not currently be practicable. Now, what does this mean? The legislation doesn't define this exhaustively, but in practice, removal might not be reasonably practicable for reasons such as travel issues, right? Like maybe this person doesn't have a passport, or maybe the country that they're going to is not going to give them a passport. They're not cooperating and they're not issuing one. And other than Australia, because Australia is pretty peaceful, when I look at the news, there's like rife and strife going out in like every country except here, honestly. And these people they may either be fleeing from there, or perhaps they're trying to go to a neighboring country, but their embassy in Australia is defunct or something. These things happen. Also, if you're stateless, right, where are you gonna get removed to? That's another issue as well. So the removal might not be something that they can do straight away because of that. But But at the same time, well, okay, then why aren't they getting a visa to be in Australia? Sometimes you have an applicant that is stateless. There's no country that they can go back to, and somehow they manage to end up in Australia. Most likely they have applied for a humanitarian visa, but they cannot get the visa granted because of character issues or identity issues. So yeah, that is when, the removal is not currently practicable. And a lot of these people, they try everything and they just end up being, unlawful, and that's just what happens. The country of origin may actually be refusing to accept the person back. The conditions may be unsafe in that country. There might be no way to get to the country. Like, what if the country is really, really secluded, or if the region is really, really difficult to get to and there's no way to get there? I can't think of any examples, but that could be a reason. There's also personal reasons like health and medical reasons, like the person just cannot get a plane to go. Or the pregnancy is too close to term. It would be very unfair for them to be on a plane, on a vessel, leaving Australia. So a lot of these medical issues might be reasons for why the removal is not currently practicable. And there's also like the issue of, and I think that this might be the issue of, let's say I'm trying to go to a Middle Eastern country at the moment and I have to take a connecting flight through Dubai because I'm flying like Arab Emirates or something. There's bombs dropping there right now, and you may not be able to go there, not to the country itself, but you may not be able to get through the third country transit. So those are other practical, like in practice, the removal is just difficult to do. For the invitation, this is a question of, well, am I going to get an invitation or not? And this is a list of red flags that the department will look at to see whether or not they should invite the person to apply for a BVR. So if you've got, obviously, if you've got a long history of, criminal offences, then no one would grant you the BVR. In fact, the department would go through a lot of pressure or a lot of criticism. Yeah, they would be highly, highly criticized if somebody who was on a removal pathway should have been detained at Villawood or wherever it is, but instead they got a BVR and then they went out and they assaulted somebody. Then the news would be all over it. They would be, they would say like, oh, we're being too soft, and it gets very, very political. So now we sort of know what a BVR is, and we know, I guess, where you could sort of get one, although you have to be invited to get one. Now let's try to put this all into actual practice and look at some recent cases that I've been looking at. So I'm not going to go through all of them, but I will go through the first one, which is Lynn. So you may or may not know the migration landmark case of Cadgi. In the case of Lynn is a clean illustration of Cadgi in action. The breach was established, but the discretion saved her. So what happened in Lynn? Okay, story time. So Mei Ying Lin, she came to Australia and she had a working holiday 417 visa. She understood the rules, right? To get a second working holiday visa, you need to complete 88 days of specified regional work. So she found a strawberry farm in Caboolture, which is in Queensland, right? And I heard that it's so hot that amongst a lot of working holiday visa holders, they call it Hellbulcher. So she found this strawberry farm in Hellbulcher through a Facebook recruitment agent. There's no written contract, there's no nothing. She got paid cash in an envelope every week. It was a Korean supervisor. The guy's name was Paul. There was a driver as well. They would take her to the farm, and she earned about $500 to $600 every week picking strawberries. And yeah, that was what happened for 88 days. When it came time to apply for the second working holiday visa, she said to the Facebook agent, hey, I need payslips to show that I've completed the 88 days. She couldn't read the payslips herself, or she didn't really understand them because of her limited English. But she applied for the second 417 and she uploaded them. She paid the visa fee, everything, and then she was granted the visa. So she got her second 417. Yay. And I think that she tried to apply for a student visa after that. Now, months later, she got a notice of consideration to cancel her visa, and she was like, well, what happened, right? Turns out that the payslips that she provided said that her superannuation fund was this fund called AusSafe, and AusSafe didn't exist. So what happened was that the payslips were just made up. They were bogus. Like the agent, the Facebook guy, just made them up. And then when she like called up the agent to be like, what is this, right? She got blocked. She called up the employer. The employer shut down the farm. The delegate just cancelled her visa under Section 109, bogus information. She tried to argue that I did the work. I went there and I was in hell, butcher, picking strawberries under the heat, making a measly $500 a week. Like, it was torture. I did those 88 days. But the delegate said, if you did the work, then give me the real payslips. And she's like, well, I don't have the real payslips because it's bogus. And they're like, why would they be bogus if you did the work? So the argument was absolutely circular. And it was an argument that the delegate was making an argument that she just could not win because that was the logic of their argument. This is where the Cadgy principle comes into play. So Cadgy, basically a one-liner of what, Cadgy was saying was that the decision maker or the tribunal has to consider the circumstances in a genuine and intellectual way. The law is not just a checklist where, one document is bogus, bam, Section 106 cancellation. That's not how Cadgy goes. So in Lynn's case, the tribunal, they first established that, the payslips, they were bogus. But she didn't provide the payslips with the intention of defrauding the department. And number two, she did do the work. She did do the whole strawberry picking for 88 days. She was a credible and believable witness as well. And she was asked. And the next bit is whether they should cancel the visa. So they thought, should we cancel the visa then? And they decided that all of the evidence weighed against cancellation. And, it's a happy ending. The visa was restored. The Section 48 bar was removed and she applied for the student visa after that. So that is a scenario where she could have been removed and everything. But that didn't happen because that's what's happening in the current world of cancellations these days, especially for Section 109. So I recommend that you read this case because it's an easy read as well. And it really, really is a good illustration of how Cadgy is applied. I'm going to talk about some airport cancellation cases because they are very interesting. In the case of Ali. Oh, by the way, so with these cancellation cases, the airport cancellation ones, the reason why I want to go through them in detail is because the real consequences of getting an injunction for an airport cancellation is not that great. Even if you win, it's not that good. There weren't that many cases in the past few years. I heard that just one airport cancellation happened last year that was brought to the FCOA, and there were 5 the year before that, and none of them were granted. But in 2003, there were like 2 out of 3 that were granted, and those 2 I have also pasted there, and they are Muhammad and Nahona. But let's go to Ali first. So Ali, right? Ali Abbas Ali. This guy was a Pakistani student studying a Bachelor of Community Services in Sydney. He'd left Australia to visit home and then, for the holidays. And then on the 31st of January 2025, so the last day of the first month last year, he landed at Adelaide International Airport, and that's when the ABF pulls him aside. And they search his bag and they search his phone, and he's detained for like 3 hours, interviewed. his phone. They put the program on the phone and they search for everything. And then guess what? The ABF finds out that he was running himself a little illegal business on the side. Australian students would be connected to his cousin in Pakistan to do their university assignments for him for like $300. So that was what he was doing while he was studying Bachelor of Communications. And Ali was like, oh, damn, I got caught, right? Because the ABF saw the messages, like what else could he do? So he admitted it immediately and he was like, I'm going to be honest about everything. And he thought that being honest and, showing remorse and all of that would be in his favor. But instead, he got handed an NOICC, a notice of intention to consider cancellation. So his student visa was about to get cancelled. He was given 20 minutes to respond to that NOICC. No lawyer, nothing. He wrote I think he wrote on a piece of paper, like, I'm very sorry for what I did. And finally, the visa got cancelled like an hour later under section 116. So conduct not contemplated by a student visa. The reasoning was pretty straightforward. You're here to study, okay? You're not here to run an academic cheating cartel. Now, I don't know how he got a lawyer, but it was at this point that the lawyers started to move really, really fast. So on Sunday, 2nd of February, so like 1.5 days later, this is the very, very night that he was about to be put on a plane back to probably Pakistan. His lawyer filed an urgent application for an injunction to stop his removal. So they did the whole thing, all of this. So they filed it in the Comcourt's portal. They called and emailed the registry, and they made the department, file the court book and everything, right? So that's what happened. 2 grounds were argued, because you can't just file it and worry about it later. You have to have a prima facie argument to be tried in the court, or else you would just be making a vexatious application. And the first ground that lawyer, Ali's lawyer, was trying to argue was that, procedural fairness. He wasn't given any time to get a lawyer or properly respond. But the court said he didn't just have the 20 minutes, okay? He had the whole 3 to 4 hours that he was detained. And it wasn't unreasonable given the context. So there was plenty of evidence to show that he was told about what will happen, and everything was explained to him very, very clearly. It wasn't like he didn't have English skills either. Remember, he was studying a bachelor degree, and it's not like he had an interpreter that would mess things up for him. So the court rejected the procedural fairness argument. And the lawyer, the other thing that they said was that, hey, it's unreasonable to cancel the visa. It's too harsh. The delegate said that because he was arguing that, my father passed away recently, and I needed money to make a life, and I'm really sorry. But he had said all of that, and the delegate was saying, hey, come on, have a heart. And the court rejected this argument too, because they said, look, yeah, I am really sorry about your father. I really am, but the misconduct was just too heavy. So all of those other mitigating factors was just not enough to outweigh the misconduct. So the injunction was not granted because they found that there wasn't a prima facie case. There were no jurisdictional error issues to talk about. But let's say, what if it was granted, right? Even if it was, the court pointed out that he would have just remained in immigration detention anyway, because he hadn't been immigration cleared. He was still at customs, and he was in an ABF facility, and he couldn't get a bridging visa E because you have to be immigration cleared to get a bridging visa E. So could he get a bridging visa R? Well, he probably couldn't, because the removal was immediately practicable. The guy had money because he had to apply. He had a student visa, so that implies that he had the funds, right? He had a passport because he just came to Australia holding that passport, and Pakistan wasn't really, one of those countries at the time, or even now arguably, right, where the conditions are so bad that as soon as he stepped foot into Pakistan, a bomb would fall on him. Like that, it wasn't that kind of scenario. So he would not have been invited for a BVR, and there was no way that he could request one. So injunction dismissed, costs of $3,000 awarded against him, and removed from Australia that night. Okay, so then we have another case here, which is, and this will be the last one that I talk about. This one is Muhammad, right? The case, however, of Muhammad is similar, but the outcome is it different? I don't know. The story is, Muhammad was coming back from overseas, somewhere really, really far away, I forget. But he was coming back after receiving medical treatment. In Australia, he was studying a diploma, but he had to cease his studies, and he'd failed a couple of assignments as well. And the department, when he came back to Australia, the department said, hey, you have failed a couple of assignments, you haven't been turning up to school, and you randomly just went to another country in the middle of the semester. I don't think that you are a genuine student, and I'm going to have to cancel your student visa at the border. So they cancelled the visa on the spot, and the whole process only took 15 minutes. But in this case, the injunction was granted because there were prima facie jurisdictional error issues to be discussed. So firstly, there were procedural fairness issues. The time that he had to respond to the NOICC was way shorter. He was on medication as well, and the flight that he had just gotten off was a 15-hour flight. So I don't think that... also, the questions that he was getting during the interview were very, very leading questions, right? And they were designed to make him feel confused and to make him admit guilt or admit wrongdoing, I guess. The Department of Home Affairs also ignored all of the reasons that he wasn't doing well in his diploma. So all of the health reasons, and also this guy's dad also passed away recently as well, right? And they just were like, look, you failed a couple of assignments, so I'm going to cancel the visa right now. But he did get the injunction for those two reasons. And the injunction was able to stay his cancellation for 1 week. So he was granted the injunction for 1 week, and then that was enough time to allow a full hearing. So it wasn't a strong win, but it was enough to keep him in Australia so that he can get a proper hearing on the evidence. So, and I don't really know what happened after that, whether he did get whether they did find that there was jurisdictional error or not. But if there was, then that means that the department was not allowed to make the decision that they did. So that is the case of Muhammad. So to conclude, as migration law specialists at Kris Ahn, we assist our clients with assessing risks of visa cancellation and removal, because our work doesn't end at the time of grant. If a visa is cancelled, we can advise on responding to cancellation notices, like the NOICC or the NOC, Notice of Cancellation. We can guide the next steps after visa cancellation or unlawful status, and if it gets really, really bad, we can file an injunction in the federal court or represent our clients in the ART. So that's it.